Okay, now it's a sign for me to start. Okay, Bismillahirrahmanirrahim. Assalamualaikum and a very good afternoon to everyone, wherever you are in this virtual platform. Welcome to all participants and viewers to this webinar session this afternoon with the title of The Art of Alternative Dispute Resolution. Very interesting topic because in the construction industry depends on coordinations, cooperations, and teamwork among the various parties. So a dispute might arise at any point during the construction process as a result of different expectations or misinterpretations of the contract document, which leads frequently to unnecessary problems and delays. Okay, next is, let me introduce myself first. My name is Hazri Abdul Aziz, moderator of this webinar. I'm humbly honored to be given this platform to be a moderator to such an incredible woman architect, of whom has been in the industry for almost 4 decades, since 1983. Amazing. I believe everyone is looking forward to her presentations this afternoon. Hope you all are ready for this afternoon talks. I'm going to make just a brief introductions about the speaker today. Otherwise, it won't end until tomorrow. It's 4 decades of an amazing journey in the architectural fraternity. Our speaker for today's webinar is architect Menaha Ramanath. Architect Menaha received a tertiary education in Portsmouth University in UK. And commenced her practice as professional architect with Pakatan Reka in 1983 after 2 years with the Armed Forces sections of the Public Work Departments, JKR, as associates with Pakatan Reka Architects since for 25 years as project architect, as project associates. Her scope mainly covered project management and implementations of commercials, hotel, retails, high-rise offices, and condominiums, residential, institutionals, and industrial developments project, from documentations for building approval until the certificates of fitness. Back then it was called CF, now it's CCC. And certificates of completions and compliance, and handover to clients. She was also the quality manager for the firm's quality management system, QMS, accredited to ISO 9001 1994 standard to ISO 9001 2008 standard from 1998 to 2009. Menaha Architect was established in 1988, concurrently primarily to provide project implementation, consultancy to resolve architect engagement dispute and contractors' construction dispute with employers. Architect Menaha has had 61 appointments of sole arbitrator to resolve disputes since 1990. Her appointments were by PAMS, LAM, and AIAC, and ad hoc appointments by parties to resolve dispute arising from architect engagement, properties, and construction industry, building contracts, and subcontracts. She also served as adjudication decisions under SIPA to adjudicate payment claims arising from construction contracts. Okay, before we proceed, if you have any questions to ask, please put in your question in the Q&A box or the chat box. And now let us proceed to the moment that you've all been waiting for our speaker to deliver her presentations. Okay, anytime when you're ready, and the platform is yours, Architect Menaha. Thank you.
Okay, I'm ready.
Yes, please proceed.
Kamalia, the first slide. And then the next one. So thank you, Architect Hazri, for my introduction. It shouldn't have been so long because I see a lot of my friends also watching this. So coming down to the business of ADR, which means alternative dispute resolution instead of going to court. So how does this impact architects? It the client and also where you are, I think, and also from the PAM form of contract. I'm only going to focus on the PAM form of contract 2018 because of the 4 modes of ADR. So next slide. When it comes to the contract between the architect and the client, it's a memorandum of agreement. And the conditions 23 and 24 allows for the architect to undergo mediation or arbitration with the client. The appointment will be by the Board of Architects if the parties do not agree on the mediator or arbitrator. Next slide. So of PAM contract 2018 with quantities and without quantities. There are 4 clauses, 34 for mediation, 35 for expert determination, 36 for adjudication, and 37 for arbitration. Why I'm going to speak speedily along these lines is because when you have learned the art of being a mediator or expert or adjudicator or arbitrator, then during the course of your contract administration, you would use these virtues in order to reduce the disputes. Next slide. So what is the goal for ADR? Although a lot of people say that going to court is faster and less costly, actually, if you do go for ADR, it does save time and confidential. It can preserve relationships because you want to continue your business in the long term. And you just want to solve the dispute immediately. It avoids litigation, otherwise you will end up a long time with lawyers and it'll cost a lot of money to engage lawyers. Opportunity, if you do have lawyers, sometimes if you have bespoke contracts and so on, it's good to have a professional legal counsels who can help you to solve problems instead of going to court and being adversarial and give you a lot of stress. Finally, ADR is to find a win-win solution for parties to achieve their goals. Because in construction, time is of the essence, and the faster you solve problems, the faster you can move on. Next slide, please. So the 4 types of ADR for the architect to consider when you and I'm focusing only on the construction contract, not on the contract or engagement document between the architect and the client. I'm only focusing on the 4 modes of ADR arising from the PAM form of contract 2018. When one does mediation, it ends up with, it is covered by the Mediation Act 2012 and the PAM mediation rules. And the end goal is a business agreement. How that happens is that in mediation, the 2 parties agree on a mediator. If not, they fill up a form and send it to PAM with a short description of what is the issue. Then after the mediator is appointed, the process is that the mediator will speak to both parties separately and then call for a meeting in a neutral place with 3 separate rooms, and the mediator will talk to each of them. It's called a caucus. And once the mediator feels that the parties are coming together, they will come together in the same room. And the people who discuss must be the top management who can make decisions. So it's like a powwow meeting, table talk. Coming to an agreement doesn't involve lawyers. The lawyer will then, or the parties will prepare an agreement, sign the agreement, then it becomes an agreement under the contract law. The other way is expert determination, especially for technical issues or specific valuation issues, where I've just described the same process. There's a form if you want the PAM president to appoint someone, or if you have appointed and want to go through the PAM expert determination rules, you can agree on, the parties can agree on the expert, and I will describe now the kind of expert you need, but according to the, sometimes my internet is unstable. So the expert determination by the PAM expert is final and binding. This is different from being an expert in arbitration or court. Adjudication under the PAM rules is an interim decision which is pending arbitration or litigation. It does not touch on the payment claims, which is mandatory under CIPA 2012. So it is an interim decision, temporary, until arbitration or litigation when you get a final decision. And arbitration will be according to the Arbitration Act and the PAM arbitration rule. Next slide, please. So when it comes to mediation, it is a flexible dispute resolution by an independent third party. The mediation rules provides for an effective, cordial, and confidential channel for communication towards early resolution of disputes and differences during the contract period. That means it can happen anytime from the start to finish of the construction contract period. It is not a condition precedent to be referred to adjudication or arbitration, and it is non-binding. How it becomes binding is if you sign an agreement to agree on the terms, and then it becomes an agreement. But it is not binding by itself if you just go through mediation. If you do not succeed in mediation, then that dispute will have to wait for how long does it take? According to the PAM mediation rules, it takes about 90 days to conclude the mediation from the date of appointment until the mediation is concluded. Next slide, please. For expert determination, expert with specialized knowledge to resolve the specified technical and or valuation issues in dispute during and post-contract period. And usually the procedural process will take about 14 days from the close of hearings, and then the expert will have to deliver the expert determination within 14 days. This can happen anytime during the construction period. It can also happen when you need an expert to determine a certain point for arbitration or and binding. Next, please. If participants want to know the rules, they can contact PAM, and the rules for the 4 modes can be sent to you Of course, the ADR committee is looking to see how to make improvements at the moment in view of the pandemic. A lot of things are going virtual. So all these modes of ADR is also happening virtually. So coming to clause 36, adjudication, it arises from the PAM form of contract clause 30.4 regarding set off by the employer during the contract period. After the date of practical completion, clause 30.4 for set-offs has to be referred to arbitration. The adjudicator has to deliver a written reasoned decision within 20. SEPA 2012 does not apply to a construction contract entered into by a natural person. That means if you're building a bungalow or a house that is not more than 4 stories, it's not covered by SEPA. So if there are small contracts involving ID works or renovation or building a bungalow, a PAM adjudication can apply. Next, please. Next slide. Thank you. Clause 37, arbitration is a private and judicial determination of any dispute or difference between employer and contractor, either during the progress or after completion or abandonment of the works. But arbitration proceedings can only commence after practical completion. Sometimes the parties disagree on the date of practical completion, disagree on determining abandonment of the works. So depending on the dispute of an arbitration matter, it can, from my own experience, arbitration can take between a few months to 2 years, depending on the parties and also the legal counsels. And the award has to be delivered within 3 months from the close of written submissions. The arbitrator's award is final and binding on the parties. If you want to know more about this, you have to look at the, I can't see on the screen, the Arbitration Act 2005, clause condition 42. The claimant came to the hearing, the respondent didn't come to the hearing on a Friday, and they needed to have an award by the Monday so that they don't have a PN17 situation. So I had to deliver the award based on a set of documents that was 2-inch thick, and I did the award by the Monday. Next clause, please. So architects may be thinking of becoming mediators, taking the position of a mediator or any of the other modes. And as Azri mentioned, I've been in ADR for a long while. And while I was doing this, it helped me to sharpen my approach when I was looking after projects for the firm that I worked of what I'm about to say is the way we present ourselves at a meeting between client and contractor, consultants, and also as a mediator. We have to be approachable, impartial, trustworthy, perceptive, and dedicated to make sure that the parties reach an agreement. So now I'll talk purely as a mediator. It also depends on the parties in mediation. It is the parties who are in control, not the mediator. The mediator is just trying to get the parties together. The parties themselves must be principled. That means they must know what it is that they want to achieve. Voluntariness means they must be really intending to come to an agreement that is legally binding, so that once they have agreed, it becomes a document and it becomes an agreement. Once it's an agreement, it is private and confidential. That means only the two people who are talking for each party, they have to be the senior people or the chairman or the bosses of the company that can discuss and negotiate on the spot. And both parties must be equal and cooperative with whatever information they have. And all this takes place in a neutral place like a hotel or a neutral building with separate rooms where the mediator can talk to the parties separately first, and then the parties get together in the central room. They can have their lawyers present. So that is the nature of mediation. Next slide, please. The expert has to be independent, has to have integrity, a high standard of technical knowledge and practical experience in the area of expertise. ADR committee has managed to have a list of people with specific knowledge to deal with specific issues that may be raised by parties that they need a decision. The expert has to be objective, impartial, and confidential. Because at the end of the day, the expert determination is going to be final and binding. The parties referring to expert determination must treat each other equally and be cooperative. They must have full disclosure of the contractual and factual issues. Otherwise, it will be difficult for the PAM expert to come to a decision. The PAM expert must also be able to specify what information is needed to come to that decision. The expert determination is on means, okay, what sort of structural system do we need? What sort of structural system do you need for a specific material or support system? For valuation, perhaps is to do with variation cost. Next slide, please. The adjudicator is similar to the expert when it's arising from set-off cost. And set-off could be to do with extension of time, LAD, things like this. What does the dollars and cents amount to become a set-off? So the adjudicator should have contract administration experience to know what sort of things happen during construction, impartial, objective, and trustworthy. Parties referring to adjudication must have voluntariness, so that later the arbitration can go on smoothly. They must have full disclosure of the events causing the reason for the set-off and the costs. Parties must have equality and cooperation. Next one, please. Slide. Arbitrator. The arbitrator is like a commercial judge. The conduct of the arbitrator is very important. And in that, the arbitrator's aptitude must have professional expertise, review testimony and evidence impartially. The arbitrator must have people management skills, communicate proficiently, juridical, that means to say, apply the law. There must be natural justice. Each party must be given a chance to present their case. The arbitrator may have full control of the proceedings. During the initial preliminary meeting, the baselines and the proceedings must be confirmed with the parties. After that, the arbitrator is in full control, because sometimes the parties may disagree. The arbitrator is asked to make a decision. When the parties come to arbitration, they have to be cooperative in terms of the facts and documents. That's called discovery of documents. The parties will exchange lists of documents they want to refer to regarding the dispute itself. There could be several disputes. The parties must be timely, because in the PAM arbitration rules, there are timelines for delivery of pleadings, and later the parties have, and the procedures are then discussed. All this is discussed at the first meeting on what is the dispute, who are the parties, when the pleadings are going to be submitted, when the documents are going to be submitted, dates for hearings, how many witnesses, and so on. Because all this will have implication on the security deposit that the arbitrator will have to call for. So the parties need to be cooperative, timely, disciplined, and must treat each other equally. This may not happen, because in my first case, the lawyers were cross-examining the other party like LA law. So I had to handle the lawyers. Okay. What are disputes that arise in arbitration, which can also come to the other mode? Kamalia, next slide, please. Thank you. So I tried to list down as many construction disputes I've come across, and this is not altogether the whole list. There could be others. And I understand that these slides will be made available so you can look at it in detail. But the architect's claim on fees will come under LAM. Certificate of non-completion, change in employer's brief means that if there are variations, there could be a large amount of omissions from the contract, or there could be large amounts of addition to the contract. All this has implications on the contract itself. And bottom line is they are disputing the dollars and cents. At the end of the day, board is saying who is to pay what to the other. That is it. So in the claims, in the pleadings, the parties may say that it could be any one or any combination of these construction disputes. For example, the issue of certificate of non-completion, sometimes I will explain a few of these disputes. Sometimes the employer will impose LED without a certificate of non-completion. It all goes back to what is in the contract. Then contractor may dispute the delay in the issuance of certificate of practical completion so that he can get release of the retention sum. There could be design error. Who is doing these shop drawings for the components and the assembly? And then there is determination of contract. Sometimes it can be a mutually agreed termination. This is not provided for in the contract, but if there is, for example, in the current situation of the pandemic, if instead of determining the contract, the architect could act in an ADR kind of position and suggest whether it should be terminated rather than determined. There are many ways of looking at it. You have to get legal counsel advice. There could be errors and omissions in design. If it's a lump sum contract, if there's an error, the contractor may say that there was an error in design. So again, if it comes to arbitration, the arbitrator will have to look at what is the error, what is the omission, liable. Final account. There could be disputes on variations in the final account. There is also a lack of coordination between consultants. So under clause 1 of the PAM form on contractors' obligations, where the contractors are supposed to bring up any non-coordinated information. So this could become, if they just went on to build without putting coordination, they might blame it on the consultants. Then it comes to, I'll go down to assessment of extension of time, assessment of variations, which affects the amount of liquidated factor. So if there is a change in the employer's brief, there could be the contract sum may be affected, and so there could be loss of opportunity and profit for the contractor. If the contractor delays the project, like a hotel or a shopping mall, there could be loss of opportunity and profit for the developer. Next one is manpower. If a project was to be done within a certain period of time, and then the employer says, no, it must be finished 1 month earlier because of their own advertising and launching, then there could be a requirement to increase manpower cost that may not follow the rates in the contract. That could become a dispute. So, endorsed by the consultants. Is it an approval? It depends very much on what sort of design intent has been given to the contractors, and to see who is at fault when it comes to the final delivery of the product. I can go on and on, but I think that looking at these construction disputes, I would advise all architects, all consultants, all contractors to also do their homework on what it is they're supposed to do, plan, discuss with the consultants before proceeding to construct. That way, you reduce the construction disputes. Next slide, please. So when things come to imbalance, a dispute arises. Facts to balance, and then there is an impact. There is an impact on dollars and cents. Next slide, please. When there are disputes, what has to happen is that for alternative dispute resolution, even before filling in the form and asking the president of PAM to appoint any one of the 4 modes of ADR persons, the parties need to understand the scope that they need to present for ADR. So when the The ADR person must understand the scope as confirmed by the disputing parties. If not clear, must ask the parties to clearly state what is in dispute, set the timetable with agreement of the parties, request the prerequisite information and facts needed to come to a decision, resolve interlocutory matters. There'll be arguments on documents, there'll be arguments on who's to produce what, there will be whether experts will be used. Do your homework on the subject matter. Keep within your jurisdiction. If they ask 3 questions, you have to answer 3 questions. Do not try to answer 5 supposed questions. You have to be very specific to answer only those questions that if the contract is in English, then the ADR is in English. If the contract is in Malay, the parties will want the decision to be in Malay. I have come across this myself. Next slide, please. Why I've listed all these acts is that if you're going to do ADR, you are going to need to refer to some of these acts. First thing, if you are doing arbitration or mediation, you need to have the Arbitration Act, the Arbitration Amendment Act 2018, and also the Mediation Act. If you are dealing with LAM appointed arbitration, you have don't see it there, but you should have the Copyright Act. There could be, basically that's what it is. If you are dealing with a PAM form of contract, you would be looking at the Contracts Act, these other acts that refer to technical issues when it comes to disputes on technical issues. For example, if you are asked to be an expert on fire escape or fire or performance design in fire escape, you need to have the Fire Services Act next to you, as well as the regulations and guidelines, circulars, etc. When you're looking at contracts to do with look at the Contracts Act, Housing Development Act, and the Strata Act, because while construction is going on, the architect also is dealing with stage completion certification in parallel to construction. And also the Street Drainage and Building Act, Uniform Building Bylaws, will deal with technical issues that arise either for expert determination or in arbitration. Yep. So I highlighted that if the developers if the developer finds that the construction for launching a hotel or the mall, he would need to have someone look at his loss of profit. So that's why I put there valuers, appraisers, and estate agents. So this is just indicative. Another thing that is not there is the Competitions Act and also the Occupational Safety and Health Act. amendments up to 2006. So I'll go on to the next slide. I did ask a few friends, what would you like me to talk about? They said, how can we avoid disputes in the first place? So I thought I'll put in the slide to show that when you're running a project, as an architect, you are in control. You are like the ship's captain. The consultants, with the contractor and the employer. You have to be diplomatic and you have to be perceptive to what is going on. So you have to have regular communication with the employer and contractor so that they give timely decisions, not crisis management. Oh, something happened. And then it will have unnecessary dispute and time impact. At the initial site meeting, set the baseline, brief the contractor on what is the design intent, run through the drawings, explain what you want as your design, as the finishes, what the employer wants in terms of the client brief and the project brief. Why I say project brief is because the client will confirm with you the client brief. What is the delivery? The project brief of the site, risk assessment in construction, and so on. And also, what are the regulations and laws that apply? What are the other similar projects? What else is happening surrounding the site, especially the infrastructure? What are the other tall buildings around? This all will affect your design. So at the initial meeting, you'd have studied all this and you would brief the contractor on the design intent. The client would be present so that they will also understand what you're telling the contractor. Then go through the construction drawings and what sort of shop drawings you need. Emphasize on the timelines because your S-curve must keep to the S-curve and not some other curve. Samples of materials, samples of workmanship. Some projects, especially high-end, some projects don't. You can still get samples of workmanship done as the work progresses. Most important is teamwork, and when the contractor sends an RFI, turnaround should be at least within 48 hours, or at least ask them when they want the answer. Now I'm ready for questions. Next slide, please. Thank you.
Right. Thank you, Architect Menaha, for your very interesting presentations. I think there's a lot of key takeaways for us to basically take and learn from that. Okay, we come to Q&A session now. I think let me start. I think we have a few questions then in the Q&A box. I'll go with someone by the names of Ganesan. Is asking whether can we get a slide, a copy of the slide.
I'm told that it will be available.
Okay, all right. And second question from Min Chia, lack of coordination between consultants. Can Architect Menaha elaborate more on this topic? As I had an experience with contractor who said they have done the due diligence but failed to find those discrepancies.
Most important is regarding coordination of consultants. The architect must study all the drawings and make sure that the design intent is met in the engineer's drawing. For example, if you have a residential project You want to look at the size of the columns. Don't take for granted. You have to look at the column schedule and so on. So even before it goes, architect, studies all the consultant's drawings and make sure that there is design coordination. So if the contractor didn't find these discrepancies, that's a good thing. But as the project goes on, you have to be alert. For example, if you have piling and the as-built piling drawings are given to you, you must make sure that the column locations are aligned in the same way. It may not become apparent, but you have to do a lot of coordination as an architect before drawings are issued for construction. If not, alert the contractor to look out for these things so that they can help you as you're going along with the project.
All right, thank you. Hope that answered your question, Mincha. Next question is from Gloria Chi. For arbitration, the decision of the arbitrator is supposed to be final and binding. What happens if any of the parties does not accept or abide with the directions or the award given by the arbitrators? I was about to ask the same questions. Is there any venue for the architects to, for the respondents to appeal on that?
Once the arbitrator has issued the final award, the arbitrator is functus officio, no more involved. So with the award, the party who wants to enforce it will take it to court for enforcement. If the other party disagrees, they will go to court and want to set it aside. If they want to set it aside, they have to look at the Arbitration Act to see what they want to do. But even from the case laws mentioned, as what I've heard at webinars from the judges at AIAC, apparently done. So in this instance, the parties will have to seek advice from their legal counsel.
All right. Okay. All right. No, you mentioned just now courts. Can you define a bit more on what are courts? Which court? A federal court or?
As far as I know, construction court. Because now they have the construction court to deal with construction matters, and you need to take it to court to get a court order for enforcement.
Okay.
I've gone through arbitration where parties and lawyers are very professional, and then after that, they deal with it. They never tell me what happens, but they deal with it. There are also cases where parties are very angry with each other still, and they might want to take it to sometimes I will get an affidavit to say they're taking it to court. I just file it away. I just file it away because I'm functus officio. After that, I don't hear anything. So sometimes to check on what's happening on my awards, I'll go into Google to see whether my name comes out, but I don't see any name and nothing comes back to me. So I can say that all my awards have been upheld so far.
Okay, all right, thank you, thank you. Okay, next questions. Can you tell us a bit about how to become a PAM mediator?
It is appropriate. First of all, you must know the technique of mediation. Mediation is not like court mediation where the judge says, go and talk to each other, mediate, and come back to me on an agreed decision. PAM for the rules. And also AIAC from time to time is conducting courses on mediation. There could be other institutions that conduct mediation courses, so that you can get an accreditation as a mediator. And then you write in to PAM president to say that you want to become a PAM, or to be on the list to be available as a PAM mediator. My training as a mediator was during the KLRCA time, and it was conducted by Australian group. It was a 1-week intensive course. So there is a technique on how you do mediation. So you can also contact AIAC to see whether they have courses, which I think RISM and AIAC have been conducting together.
Architect Hazir, you're on mute.
That question came from Tong Jia Chen. Hope that answers. Okay, next question is from Cho Leong Hui. What is the reason that education should be the condition precedence before going for arbitrations, as you have mentioned?
Actually, adjudication can happen during the construction period. It is a temporary decision. It is not final and binding. But if the parties come to an agreement, then it becomes an agreement. They need not go to arbitration as at the end. But as time goes on, if the set-offs start to change because the conditions have changed, then after practical completion, it has to be referred to arbitration. It's just a temporary decision. I've not come across this in PAM. But if you are having a bungalow and you have a dispute between the employer and the contractor on something, then you can go to adjudication. Keep it simple and fast.
Okay, all right. Thank you for the answer. Next question is from Kiao Tu Min. Can PAM form of contracts be used in foreign countries? That's like neighboring countries, Thailand, Brunei, and Myanmar. How shall we implement in the event of clients from those countries are agreed to do so? Applicable in foreign countries, is that that is the questions.
I've not come across this, but if one understands contract, it is the parties who decide on the form of a lot of the conditions have been extracted, and I've seen it in contracts which doesn't say PAM. They've just copied all of it. Becomes a contract between the two parties. So, in my opinion, the PAM form of contract, because of the conditions as set out, if the two parties agree to it, it's up to them. But they may decide who is the administrator of the contract, because in the PAM form, it refers to the architect. Sometimes the PAM form is used in other contracts, engineering contracts even, where they take out the word architect and put in engineer, or they take out the name and put in project manager, or they change it to SO. Then in the SO, they describe the superintending. At the end of the day, it is a list of conditions. If the two parties want to agree, it's up to them whether they want to adopt it or follow it entirely.
All right. Okay. Thank you for that answers. Next one is from Cho Leong Hui. What is the reason that SIPA would not be referred to for building below 4 stories? I think before you answer that, Architect Menaha, I would like to ask attendees if you had any question. I saw some of the questions that have been posted in the chat box. Appreciate if you can post it in the Q&A box, shift it to the Q&A box so that it will be easier, so that it will be in sequence and in order for me to read it. Thank you. All right, Architect Menaha, what's the reason that SIPA would not be referred to for building below 4 stories? Is there any other reason?
Because all SIPA adjudications are administered by the AIAC. It is, I have extracted it from the AIAC SIPA handbook.
Okay, all right. Thank you. Next question, so I think I'll take it from the chat box. It's from Vignesh Warren. Are we bound for life as architects or can be referred to the Limitation Act for our designs?
My understanding is for life, but we have to study the Limitations Act. And also, if you're the architect of a building, once the building has undergone renovation or something else, you cannot be held responsible. As I have asked in my projects to the consultants, prepare the design brief, which is part of the document to be handed over to the employer when the building is finished, and put your disclaimer there to say that you are only responsible for your design. If there are any changes, you're no longer liable. Perhaps we should consider, think about that under practice committee.
All right. Thank you.
To consider that, to advise, to do a practice note for architects.
Okay, next questions from Chiam P. If in the NSC contract, main contractor disputed with the NSC on the provisions stipulated in the NSC contracts, does employer needs to be dragged into as another dispute party?
NSC, yes. Nominated subcontractor, then no, it is between them, because the NSC has some protection where they will bring in the employer. But as I said, these things are something to establish at the first initial site meeting so that we don't get dragged into a situation like this. There is a comment in the chat box regarding the design brief. I will elaborate on that because as architects, when we are designing, we are coordinating a matrix of actions involving structural system. And now with the COVID situation, the environmental impact inside the building, natural ventilation, aircon, how. Another thing is the structural engineer's design brief. Sometimes the end users may misuse the building. Again, the M&E to do their design brief, especially on fire, to say that what the building is designed for, what are the protection systems. If they then change the use of the building without going through any submission of drawings and so on, how can you be held responsible? So usually, nearing practical completion, I will remind the consultants to prepare the design brief for architect, M&E, CNS, landscape, everything, so that you can have a disclaimer to say that if you do anything else, don't call us.
Architect Hazri, your microphone.
Okay, next question. Is there a limit of liability for architects, consultants stated in PEM contracts? From Fiona Liu.
I think there's some case law going on at the moment. I'm not too familiar. But my understanding is that if you are the certifier, yes, you are liable. And if you are a professional architect working in a firm, running a project, I've seen a case law from UK where it says that you're also liable for that area that you are involved in. So that is why we have to do our homework and be up to date of what is going on. On the question of liability, I think I have to do some homework on that too.
Okay, all right. Seems like there's no other question from the Q&A box, as well as the, let me check in the chat box. Well explained and shared, Architect Menaha, on the disclaimer of the design brief. I think that is from Mong Men. Okay, any direct questions, or if you had any direct, if you want to speak directly, if you want to ask directly to Architect Menaha, please raise hand. There's a command raise hand there, down there, bottom, at the bottom there. I think before we end, I think we'd like to take one more question just now. Yes. From Gloria Chi, can an architect substitute payments? I think you need to look at the chat box.
Yes, I am looking at the question.
Okay.
If there are overdue payments,
Yes.
it's up to you. Because I've come across situations where that has happened. Whether can or cannot, you have to look at your agreement with the client.
Okay, it goes back to the contracts that you sign in.
Yes.
Okay, I had perhaps one last question, if there is no in the chat box or in the Q&A box before we end. Oh, there is another questions from Chum. Then I leave my question to the last. In my earlier question, what if the clients SO had earlier written to the MC giving an assessment? Would the employer be dragged into as another dispute party? It is regarding the NSC that this Chum asked before.
MC, main contractor. What if the client's SO had earlier written to the main contractor giving an assessment? Would the employer be dragged into as a... Well, when it comes to a contract, the parties are the main contractor and the employer. So if it goes into dispute, yes. Because the contract is between the employer, the client, and the contractor.
Okay. All right. Thank you. Oh, there is a response from him. No, the contract is between the the main con and the NSC. That's what he's saying.
Oh.
The contract between it's a NSC contract between the main con and the NSC. So whether the employer should be pulled into their disputes.
It's very unlikely the employer has much to contribute to such a dispute because it's between the main con and the NSC. possibly the consultant concerned will have to step in. There's no reason to drag in the employer because the SO is the agent for the employer in the contract. But if the lawyers and the but it's not good for the long term to do that.
Yeah. Okay, I hope that answered the questions by Chiam. Okay, perhaps this will be the last question before we end. You know, you mentioned in your last slide, in a few slides before the conclusions, it was saying that regular communication with the employer and contractors. You know, usually when you speak or you had a meeting with your employer or contractors, whoever that is, or even the local authorities, people tend to, you know, they just go back after the meeting, they don't record it. So what is your take on that? Should you know, regular communication, and what's next? What are the things that if the architect, what are the architects need to do after that? Or they just leave it like that? Do they need to, you know, record it and write it back to the, you know, as a record, as what has been transpired during the meetings?
It's always good to
What's your
record.
take on that?
It's always good to record what is happening, and because later on you can refer to it. So when I say both, that means that sometimes you need to explain whatever the employer needs to know regarding what is happening. Once they understand, then that's okay. Same with the contractor, why certain decisions are being made. In other words, to be objective and clear to both sides when the project is running.
All right. Thank you. Thank you very much. Okay. I think we'll come to the end of the sections unless I think there's no other question from the Q&A box. If that's so, perhaps your advice before we end the session, Architect Menaha, what would be your advice to, you know, you have said enough in the even in your slides you mentioned that. So a few words before we conclude.
Thank you very much for inviting me to do this paper. I think a lot of people don't understand the relationship of one mode against the other. I suggest that that you write in to PAM and ask for the various rules, and then based on the items that I raised, I believe the slides are available, to do homework and just have continuous learning so that we are up to date and better at what we do. That's all.
Yeah. Okay, thank you. I think that is a very great advice from you, from someone that has been in the practice for many, many years. Okay, thank you very much, Architect Menaha, for your interesting session this afternoon. And there's so many key takeaways that we can take from these webinars. A lot of items that very much relates near to us as an architects, what we can do or take away from this. Okay, with that, I hope everyone benefits from this webinar as much as I do. I really do. With that, I thank you